for your patience as well today.
Thank you, Chairman, for your service on a very long day. And thank you for having me here. Chairman Leach, members of the committee, my name is Jim Perdue, Jr. I'm from Texas Trial Lawyers Association, and I'm here on the bill. I've talked to Representative Smith, and so I wanted to be clear. And I'm a little more than a resource witness because I do have some concerns, and they reside actually in your question, Representative Schofield. There is no fundamental objection, I think, to the changes that are enacted in 161A regarding the Supreme Court or even having retired judges, which I understand was to address, for example, one potential appointee to some MDL panel that was created down in Houston. The main issue that I do want to address, however, is in 162 and line 17, specifically this addition of common questions of law. In the history of the MDL statute, which was created in 2003 via HB4, by the way, it was part of the tort reform package of 2003. There have been a total of 109 petitions for removal to the MDL in Texas law. 67 of those have been granted. All of them involve a finding that there are common questions of fact. Here's the background. The federal MDL statute, which is in the 28 U.S.C. 1407, says common questions of fact. So the federal MDL statute on which the Texas MDL statute is based has always looked at commonality of fact as being the basis, and it does not recognize commonality of law. Now, here's the pragmatics. There have been a variety of MDLs created regarding the situation that was arisen, which is the interpretation of coverage. There are a host of MDLs, In-Ray Farmers Insurance Company, Harvey Litigation, In-Ray TWIA, that have dealt with coverage question of commonality of people with a single carrier. And in the federal litigation right now, specific to COVID business interruption, the issue of a global MDL regarding the interpretation was created, and the federal MDL panel said that's not a commonality, but we can do it per insurer under our jurisdiction on common questions of fact. So we have an MDL created in Ray Society Insurance Company by the federal MDL. So I think the solution regarding insurance is actually built into the system we have. We've had insurance coverage questions interpreted under commonality of fact. And I think it's dangerous, Representative Schofield, to have the idea, for example, COVID, ERCOT sovereign immunity has been raised as a legal question. There was ERCOT sovereign immunity raised before the freeze in two different settings of a rate hike and then also of a plant that built $1 billion production plant at COVID. And there's a question of sovereign immunity in that case, question of sovereign immunity in a different case, and now post-freeze, there's a host of questions about ERCOT sovereign immunity. They are not joined by fact, but they are a common question of law. It's dangerous to have those subject to consolidation because they're very different questions. So that's the concern with the bill. I've raised it with Representative Smith. I do think the system we have now and even the federal system reflects that common questions of fact can be answered in a coverage question. And so respectfully, Chairman and members, that's my testimony. It's late, and y'all have been very, very patient.
Thank you. Representative Schofield.
Oh, sure. My bill you testify against. This one you're on. Okay.
You've laid out four today, and
I've only testified against one of them. That's not too bad. That's not a bad batting average. Yeah, because I understand what Representative Smith's trying to do here, and I like it, and I like our MDL. I think it works very well, but I'm concerned about how common questions of law would work. The reason why common questions of fact work is that they're common questions of fact. You have the same case. Just, pipes leaked, my basement flooded, and they denied coverage, and we have a bunch of leaks, or the Harvey comes through, I flood naturally, they deny coverage. Obviously they would because it's not flood insurance. But, we kind of know it's the same case. You can tee them up together. But I worry that even though and I was kind of facetious with my example of libel earlier, but where the question of law is the same, but that's all that's the same. And ERCOT sovereign immunity might be a good point there. Freeze sovereign immunity. You have all those cases. Maybe you could put them together under common questions of fact. But some of the other issues, you might say, okay, my question is, does ERCOT have sovereign immunity? But my fact pattern that leads me to come up with that has to do with something entirely different.
So, for example, there has been an MDL created relating to the In re Winter Storm Uri litigation. They're all related to damages specifically related to the power grid failure, but that they have a commonality effect. It's a very big MDL. It will be huge. But most of the MDLs in Texas have been Volkswagen admissions, Toyota acceleration. But now you're talking about a question of contract interpretation by potentially different parties. Or, for example, TTCA immunity, right? You could have a case against a Tort Claims Act in one instance. You'd have Texas Tort Claims Act in another instance. They share a common question of fact on sovereign immunity, but they share no basis in, they share a common question of law.
I mean, I guess my question kind of comes down to, are we converting the MDL to an appellate court before the trial? Instead of, where when we had Judge Davidson earlier, he's talking about teeing up your facts for trial and your discovery and doing all the complicated issues that each individual judge, while competent, still would struggle to do. Here you're saying, give me the appellate ruling on whether this is law or not, and we'll have one for the state. I think that's a different thing than what we have, and maybe that is where we want to go. But it's a different animal than I think than the MDL that we've had previously. And again, maybe that is where we want to go. But I think we ought to know that's where we're going.
Representative Smith.
Mike, I appreciate your comments on that. Jim, I certainly appreciate your time and coming to me and talking to me about this. I wanted to kind of reiterate a point, though, that was made by Mr. Parsley a moment ago. My reading of the government code on this is, you've got 5 panel members. In order for them to do anything, it takes 3 of them under 74.161, right?
Right.
Okay. And then they make a determination under 74.162 as to whether or not they're going to accept an MDL, right, based on a lot of discretionary points. A transfer may be made by the Judicial Panel on Multi-District Litigation on its determination that the transfer will, 1, be for the convenience of the parties and witnesses, and 2, promote the just and efficient conduct of the actions. Is that your understanding of the two things?
It absolutely is, and it's the criteria that's used in the federal system as well.
Okay. So you're talking about 5 guys that are going to decide whether or not they're going to take on a whole bunch of litigation, potentially, right? I was thinking, and I think what law or fact, and I think Mr. Parsley raised an issue about this particular coverage issue, and your point and counterpoint on that is well taken. But this expands the flexibility that these guys have in their discretion. They don't have to take it as to whether or not they're going to take the case. And I'm assuming that you and I both realize we're not smart enough to foresee every situation that's going to come to this MDL consideration.
And maybe that's why I'm raising this issue on this expansion. Judge David Evans from Fort Worth is the chair of the MDL panel right now. Ken Wise, who's a good friend of mine, is on that panel as well. I trust their discretion, so I'm not casting aspersions that if you broaden their discretion, we might get some things that shouldn't be in an MDL. But it is an issue of concern because it doesn't track the federal language, and that's what I wanted to raise with you.
Okay. Well, let's certainly have some more conversations about it. And I appreciate you again, and Mr. Schofield for his comments.
Well, I appreciate you and for talking to me about it, and I appreciate y'all taking the time because I know everybody's exhausted. So thank you very much.
Thank you, members. Any other questions? All right, thank you.